So hello and welcome to the Clerks Legal seminar or webinar on Route Out of the Pandemic. We'd like to welcome you to this webinar. I'm Helen Beech, I'm a partner at Clerks Legal, and this is Georgia Roberts, who is one of my senior solicitors in the employment team. We are going to spend the next 45 minutes taking you through some of the challenges that employers are going to face in their businesses as they start to reopen following the government's announcement yesterday, and as government support is starting to reduce following the announcement yesterday. We had the roadmap out of the pandemic advised to us yesterday, and we can see that that is going to be a staged process depending on the sector in which you are in. And we know that the last group that is going to open are those office-based businesses. At the moment, the mandate is that it is work from home if you can. And so it means that those offices are likely to not be going back until perhaps around the June time. But what we're going to look at now between us for the next 45 minutes is the furlough scheme and what that might look like over the next few months. And then we're going to look at restructuring and redundancies and what businesses might be looking at. And then we're going to look at businesses that might want to be changing terms and conditions and what the sort of blended arrangements might look like. And then we're going to conclude with perhaps some of the more controversial topics that all of you may have been reading about in the press, particularly around, as individuals start coming back into the workplace, the wearing of masks, and perhaps the most controversial topic of all, the vaccinations, and whether or not you can force employees to actually be vaccinated. So without any more ado, I'm going to pass over to Georgia, who will start with the furlough scheme. I will point out before we conclude, hopefully we will have time for a few questions at the end. But now looking at the furlough scheme and where we are.
Perfect. Thanks, Helen. So whilst an announcement about furlough wasn't made yesterday, the Prime Minister did say that Rishi Sunak, the Chancellor, will be mentioning further measures for businesses next week in the budget. So an extension to the scheme is expected and is predicted. At the moment, obviously, it's due to end at the end of April, but we know restrictions are going to remain in place, at least in some part, until the end of June. So we expect there will be an extension to furlough of some sorts to match that. So what we wanted to talk to you about today is really just using the furlough scheme while you can, if it's going to help and support your business. It's available for all employees that were on the payroll on the 30th of October, and individuals don't have to have been furloughed before to benefit from the scheme now. We wanted to talk today about how you select employees for furlough, because it's really important that this selection process is fair to avoid any discrimination claims. So we know, for example, that employees that have caring responsibilities can be furloughed, as well as employees who've been asked to shield and who are clinically extremely vulnerable. For other employees, perhaps those who share a lot of roles, it's thinking about how you select those people and whether you can use the flexi furlough scheme to protect the business when thinking about how those selection decisions have been made. Helen is going to talk to us in a little bit actually about how selection for furlough can come as problematic when we think about, and if you have to move towards redundancies as well. But it's thinking about those groups of people that have perhaps been on furlough for nearly a year now, who could potentially have those indirect discrimination claims, for example, parents, pregnant women, people in those sort of categories. We also know now that HMRC has started to conduct audits into the furlough scheme, and these audits are about the conditions for the receipt of grants, as well as the amounts that are being claimed under the scheme. In September, it was reported that £3.5 billion has actually already been claimed fraudulently. So we just wanted to make you aware of two particular points today about what the scheme should and shouldn't be used for. So in relation to sick leave, employees that are on short-term sick and those who've been asked to self-isolate shouldn't be furloughed. They should be placed on SSP, and the scheme is really clear about that. However, employees that are on long-term sick can be placed on furlough. So there may be a period sort of in the middle where you've got employees who initially went off in the short term, whose sickness absence is now moving towards the long term, where it may be a bit of a grey area for you to decide whether you can actually furlough them. In those sort of examples, we'd say take legal advice, just so it's really specific to your particular query at that time. In relation to holidays, we know that holiday accrues for employees who are on furlough, and employees who are on furlough can take holiday as well. Now, the really important point to make about this is when employees take holiday on furlough, that must be topped up and paid at the normal rate. So what we imagine as part of the audits of the HMRC scheme will cover is for those employees who perhaps say, right, I'm taking 2 weeks holiday, and the employer thinks, oh great, okay, we can furlough them for the 2 weeks so we can recover 80% of their wages. We know that you can't do that under the scheme. So that's going to be a really, really important one to watch out for. As I've mentioned already, we are expecting an extension to the scheme as well.
One of the things we were just looking at in terms of audit as well is making sure that you keep a record for these audits and spot checks. So hanging on to the data, holding it for 6 years is going to be critical. And of course, having a record of your furlough consents. So individuals agreeing to go on to furlough, you have to keep a record of those. There should be a written documentation of that. So make sure that information is readily available in case you are spot checked.
Yeah, exactly. The government has actually carved out under the words of the scheme that it has the right to retrospectively audit. So we know that the records must be kept for 6 years, so your audit could come at any time over those next 6 years as well. And now, as I've mentioned, I'm going to pass back over to Helen, who's going to be talking about restructures, redundancies and dismissals.
So this is something now that we are getting more inquiries about, particularly if the furlough scheme is going to come to an end, if it's going to follow the government's review process. If it looks like we're going to get back to some sort of normality, perhaps towards June or July, we're anticipating that the furlough scheme may also come to an end at around that time. So we have a few more months after the April period, which is the current scheme. And so we think companies may start to look at restructuring, possibly dismissals, depending on where they are at this stage. Remember that with regard to redundancy pay and notice pay, the rules under the furlough scheme changed, and so you cannot recover those payments under the furlough scheme. Consultation is still required for redundancy. You cannot avoid it just because people are on furlough, so they're not out of sight and out of mind. And also individuals themselves can't avoid engaging in the redundancy consultation process just because they're on furlough. Or individuals cannot suggest that they can't be reps for the purposes of collective consultation processes, because we all have this issue around what is work for the purposes of the furlough scheme. Certainly engaging in a consultation process as an individual or as a rep is perfectly acceptable under the furlough scheme. It does mean that you may have to, particularly if you're an office-based employer, that you're going to have to engage in virtual processes. You can't avoid it. And we certainly know that if you're involved in collective processes, that it's highly unlikely that you're going to be able to use COVID-19 as special circumstances for avoiding going into collective consultation processes. So you'll need to engage with those. If you're doing 20 or more redundancies, you're going to have to elect reps and go into collective and individual consultation. We have already had some inquiries from employers who have had perhaps a mixture of employees on furlough, but also some who are still working, but they may need to pool them for redundancy purposes, and they have considered actually putting them all on furlough whilst they're consulting with them. We actually think that may be considered an abuse of the furlough process, to actually put those that were working onto furlough just for consultation purposes on the basis that their jobs may become at risk and they may not be coming back. It's a little bit like looking at the fact that redundancy pay and notice pay is not recoverable under the scheme. We wonder, why would you put somebody on furlough suddenly just for consultation? And so we think that's a risky decision to make. So be very careful about what you do in the consultation process. Then selecting those on furlough, possibly to make them redundant. Again, this is looking at why did people go on furlough, and just talking to your managers and making sure they're very careful about how you select for redundancy now, if that's what you're going to do. Bearing in mind that people may have actually chosen or even asked to go onto furlough for all sorts of reasons way back last March. People may have gone onto furlough because of their age risk, their own personal profile. It may be that they had caring responsibilities. They may have been from the BAME community and felt that they were high risk. And these may have been things that actually were agreed with the employer at the time. But it also means that now, when you come to redundancy, they could be a discrimination risk if the managers think actually this person has been out of the business for a long time, we've had other people in the business doing all the work, and they become the automatic selection for redundancy because they've been away from the business. So thinking about your processes for pooling and who's in the process and how you're going to do it becomes critical, because I've listed there on the slide, you'll see where you're possibly at risk for discrimination claims.
Yeah, exactly. And we've been discussing actually the difficulty with selection criteria and how to really make this objective. As Helen said, you're going to have people who have potentially been out of the business for a year on furlough. So when they're pulled and they undertake a selection criteria and a scoring criteria of people who are out of the business for a year versus those who've been working, it's going to be really hard to score them and to score them fairly. And you might have risk of claims for employees who are saying, well, this scoring process isn't fair because I haven't had a chance to work in the last year because I've had to be furloughed. So we've actually been thinking, if you're doing a scoring exercise, maybe it's looking at work from February, January, even into December 2019 and the beginning of last year to actually do a scoring system that it is objective.
Yeah, and then I've just put on the slide there, looking at other options. Certainly VR, many businesses often don't consider VR, but it might be something where many people have reassessed their lives during the pandemic, and VR may be something that actually gets you results that you want, where individuals are more comfortable taking VR. And also then, if you don't want to go down the redundancy route, but want to retain people, but they can't come back yet, you have options like sabbaticals, unpaid leave, and you may even have put a layoff clause into your contracts back in March, where we were redrafting contracts for furlough, but we actually put wider contractual terms in that allowed us to lay off, and that may be something that you can do rather than go into redundancy immediately. So just look at the other options as well as part of this process. So then moving on to looking at, once you're coming back into the workplace, what are the new issues that we might have to address?
Yeah, exactly. So we're getting the workforce back now, but COVID is still going to be a risk in the workplace, even with more and more vaccinations, which we'll be covering later. So first of all, we just wanted to mention the COVID status certification that the Prime Minister set out in his announcement yesterday. Now, there isn't too much information on this at the moment, but we know that this is something that's going to be under the government review, perhaps in stage 3. So that's going to be probably taking place in around May. And what this is essentially a vaccine passport. So requiring people to have had the vaccine to go into pubs, restaurants and busy places. And then that got us having the discussion, well, if you're requiring the public to have that vaccine passport, then it's likely that the employees that work in those venues, that work in pubs, restaurants, perhaps retail as well, maybe they're going to need the vaccine passport as well, so that the protection is 2 ways. And then it got us thinking, well, if that's going to be the case in that setting, how different is that to an office where you've got lots of people coming and going? So this is something that we're going to be tracking to see the sort of the review and the pace of change, but something we're potentially thinking could happen in the workplace moving forward. What we do know, and as it's already started happening, is the Health and Safety Executive have been conducting spot checks and inspections on workplaces to ensure that they're meeting their COVID safe criteria as set out by the government across sectors. The HSE are actually encouraging employees to come forward and report their employers if employees do not feel safe or feel like the safety measures their employers have taken have been enough. This is really interesting because in the sort of office environment, there hasn't really been this kind of stringent view on health and safety that we're seeing now in the wake of COVID. Businesses that operate, with food, in warehouses, or perhaps with animals in those sort of environments, they'll be very used to having stringent health and safety benchmarks that they need to meet. Whereas in the office environment, this is the first time that we're really seeing sort of stringent rules that are being enforced, and that's being carried out at the moment. And as part of that health and safety in the workplace, there's also the consideration of testing. So the government at the moment is carrying out a rapid testing scheme. This is available for businesses who have 50 or more employees in sectors that specifically can't work from home. Those employers can get free tests from the government to carry out testing on all of their workforce, and this is really to highlight and try and tease out those positive cases for individuals that have no symptoms. So isolating those asymptomatic cases within your workplace to protect others and prevent the spread. This may be something, if you don't qualify for the government rapid testing, or perhaps at the moment you're still working from home, but you've got some people coming in, or as things open up, you might decide that you want to do a company testing scheme. And we've actually got a checklist on this that we're going to be sending to you at the end of the session, because there are lots of legal implications to consider when thinking about whether to run a company testing scheme. One of those implications will be all of your GDPR requirements in terms of protecting that personal data for the individuals you're testing. But the others is the really, really stringent requirements to report those tests to Public Health England. And the reporting requirements are for positive, negative and inconclusive cases, and they need to be reported. It's in the guidance, it says immediately, but failing that within the first 24 hours. As well as this, you may want to start thinking about your systems for dealing with cases in the workplace. And it might be that you've already thought about this last year when office spaces and sectors started to open up again. What is your reporting system for dealing with cases? How are employees going to be told? It may be that you want to get consent from all your employees so that you can tell individuals who has a positive case, if they've got one, in order to manage risk and to deal with who needs to self-isolate. Alternatively, employees may want to keep that information private, so it's making sure that you're able to communicate within the workplace where there's been a case without giving away that sensitive data of the individual. Finally, we just wanted to mention on this slide is the fines. There are fines payable by employers who force employees to still come into work where they've either had a positive test or they've been told to self-isolate by test and trace or a local authority. The fine is currently £1,000 for the first offence, and that's both for the employer and the employee. And then for the employer, it rises to £10,000 depending on repeat offences. So that's the kind of COVID implications of getting everybody back to work. And now I just want to come on to managing the new issues of perhaps having a blended team. And I'm not sure if many of you will have seen, but last week on LinkedIn, the problem of hybrid work was sort of circulating as one of their news articles. And there was a big report by the Financial Times, which actually referred to the mixed model of hybrid working between home and office as complete horror. Now, we think that wording is probably quite strong, but thinking about the issues that having a blended team and a hybrid workspace can pose is really, really interesting. So the first one we put on the slide there is visibility. And so this is where managers start to favour people who they can physically see in the office. And it may not be conscious, it may just be subconscious that when work comes up, it's automatically delegated to the people that are right in front of them that they can see, meaning that those people who are continuing to work from home miss out on opportunities. As well as this, there's lots of research and studies into remote working, because obviously in general remote working isn't a new thing, but there are lots of studies about remote workers' routes to promotion and development are a lot slower than those who are in the office. So it's thinking about the type of people that may be continuing to work from home. So will this have a disproportionate impact on women, for example, who may be finding that they have a better work-life balance by continuing to work from home? Or will it be perhaps certain ethnic minorities or age groups who are continuing to work from home whilst they're waiting for their vaccine? Will this have a disproportionate effect on them by not being in the office and being with their team? On this point then, with the Financial Times article, with other reports that we're starting to see at the moment with people working from home for nearly a year now, is the impact this has on productivity. The reports coming through suggest that you get the maximum productivity when you have all of your team in the workforce, working together at the same time. So this is going to be thinking about how you're going to structure that return to work. It might be that home working has been really beneficial for your business, and you'll find actually we're going to say it's 3 days in the office and 2 working from home when things open up again. But really thinking about how stringent you're going to be with that. If you give employees maximum flexibility, for example, you may end up with half the team in on one day, only a couple of people in on another. So thinking about back to perhaps when you did the bubbles in July sort of time when things opened up, and having that structure and requiring people, okay, the 3 days you're going to be working are Monday, Tuesday, Wednesday, so that you're really benefiting from that maximum, having everybody in and the team on those certain days. And so following on from that and thinking more about the blended team and the hybrid workforce, Helen is going to continue about making maybe more permanent changes.
Yeah, so looking at your arrangements, particularly for office and home working, it's actually putting those into place and making those more permanent. First of all, why are you making the changes? It may be that your contracts of employment actually work already for you and you have the flexibilities written into them, but it may be that you don't, and you actually need to look at making changes for whatever working arrangements that you need to put in place and that you think that you're going to make those changes for the future. And I suspect in many cases you won't have the flexibility for place of work changes. So if you are looking at doing more home working, it's perfectly possible to have 2 permanent places of work, so a home base and an office base. That's perfectly possible. But I suspect many contracts of employment don't have that flexibility to make somebody's home their permanent place of work or one of the permanent places of work. And you probably will want to include, even if you make that change, you may want to have other related terms to go with it. So the right of access, maybe even a trial period, the ability to be able to call people into the office for certain meetings, insurance issues, data protection issues, security of equipment, etc., etc. So all of those things may be something that you want to actually get changed on a permanent basis. So how do you go about making those changes? Well, three options. Consent, obviously the easiest one. If you can do it by consent, great. Flexibility clauses, so I've already mentioned that, of course, if you have the flexibility, great. But be very careful, because there's a difference between a specific flexibility clause that allows you to make the change and then a general flexibility clause. I suspect many contracts have that nice general clause at the bottom of the contract says, you know, the company can make any change to your contract on a month's notice. Please don't rely on any type of clause like that to make a fundamental change to somebody's working arrangements or place of work, because that clause is not adequate. Or ultimately you have to impose the change if you can't get agreement. And if you're going to impose it, then that means we're going to have to go through a consultation process with the individual. It may be, again, you've got obligations to go through collective consultation if you're looking at termination and re-engagement processes. And it might be that you're terminating 20 or more employees. If you're looking at that, then you it's like the redundancy processes, and you have to elect reps to do that. What I would say is, if you are a unionized organization, please be very careful, extra cautious, because some of the terms and conditions that you might be trying to change may actually be incorporated into union agreements, and therefore you're going to have to actually change the union agreements as well. And if you can't get those changed, you may actually have to terminate union agreements. And so that may actually mean there's notice provisions to change them that take 6 months or more. And in fact, you can't then just offer sort of sweeteners to employees to go over the heads of unions. To do that actually is illegal, and it may involve significant fines against the organisation. So all I would say is, if you're unionised, please be extra cautious, and you may need to take legal advice on how you go through that collective process to make changes. Other than that, you may have employees actually making flexible working requests, because it's not the employer that wants the change, it's actually the employee that wants the change. And then it's about looking at what goes alongside the contract change. It's actually looking at updating policies and management guidance about how those changes are going to work. And so you'll be looking at perhaps who's paying for travel costs between home and work, you know, who's paying what expenses, COVID safe behaviours when you're in the office, harassment issues about people's behaviours and people making comments about, you know, who's away from the office and why they're away, who's not in and why they're not in, and disciplinary processes. We've already had cases involving individuals who have deliberately actually made contacts about their with COVID and actually shut a workplace down. And so having to deal with, you know, malicious behaviour around COVID. So you will perhaps want to update your disciplinary policies to deal with COVID specific behaviours as well. So just those sorts of things to think about.
Yeah, exactly. I'd just also add to that we also have a fact sheet on changing terms and conditions as well for you that we can send you at the end. And we're recommending this for businesses who perhaps have decided to downsize because of the pandemic, to actually need employees to work from home, for example, on certain days, so that they can manage those sort of hot desking arrangements.
Yeah. So then looking at the next hot topic is wearing masks at work. So as we start to move into an environment where people are coming back or they're already back, you know, as shops are going to be able to open fairly soon, what about wearing masks at work? So Georgia will start.
Yeah, exactly. So we've got updated government guidance on the 10th of January on PPE and face masks for various sectors. And there's quite a lot of sectors now where mask wearing is mandatory. The issue which has been cropping up for us and for our clients in the work that we do is around the exemptions. So people exempt from masks are those with physical or mental impairments, disabilities, or if it causes severe distress. So the interesting point about this is you do not need your employees to provide written evidence of that exemption, and government guidance on this actually states that you shouldn't be routinely asked to provide any evidence of this exemption as well. So you don't need a medical certificate. The really interesting point with masks is obviously it doesn't particularly protect the user or the wearer of the mask, it protects others. So it becomes a real issue then when you have employees who aren't wearing them for the wider employment community. So Helen's going to talk to you about this now in the context of retail space.
Yeah, so we'll all have dealt with the issue of face coverings in retail, because whether we actually work in retail or whether we're actually customers in retail. So staff and customers must wear a face covering unless exempt or behind a physical barrier if you're actually serving. And so the issue in this particular sector, but it will apply to some other sectors who actually have the same obligations in this context, is about wearing the face mask. So as an employer dictating to employees in this sector, and employees actually not wanting to wear a face mask or suggesting that they are exempt from wearing the face mask, and issues of non-compliance. And how do you manage those issues? Because for this sector, it can be very problematic. So the risk of transmission is very significant, and obviously has become more significant with the new variants of COVID, which we know has become more spreadable. And so the risk of transmission has increased, and so you're working alongside your colleagues, but also it's a customer and public facing business. And so we have already been dealing with issues for various clients on this matter. And so what we're doing is taking a staged approach to it, because there is also a serious issue here, not only with the issue of transmission, but also with customer perception. We're asking people who are coming into stores to wear masks. There's a reputational issue here that if people are coming into the stores and seeing that perhaps half of the staff are not wearing masks, there is a reputation issue. So it may be that within your organisation, what if you're running a pub or a hotel or any sort of hospitality sector, that if half your staff or more are saying, I can't wear a mask for whatever reason, then it actually is a perception issue. So what we're looking at is a staged approach to how we deal with it. And so first of all, looking at why. Now it may be there is a disability angle And so the individual may have a particular physical disability or some reason why they can't. But in many cases, what we are finding is that this is the first time the individual has indicated a reason why they can't wear the face mask. It may be this is the first time they've expressed any anxiety about wearing it. It may be the pandemic itself and the actual wearing of the face mask is causing the anxiety, so it's the first time. So what we're looking at is what support and information can we give the individual to assist them to try and alleviate that anxiety? Can we provide them with CBT through any sort of occupational health or sort of system that the company has to provide that support? Are there any other roles that we might put that individual into that means that they have less contact with the public or with customers or actually with work colleagues? And as a last resort, if that is not possible, then it's whether or not we furlough. Finally, if that is not possible, or if the employer doesn't want to do that, it may actually be dismissal. And then, of course, the risks of claims there are possibly disability, but bearing in mind that there may not be a disability with this type of anxiety and the extent to how long that may have lasted, and or possibly a Wages Act claim if they've been furloughed with the 20% reduction. And so we are seeing those sorts of claims being pursued. So it's a staged approach, but actually taking quite a robust approach in these cases and seeing where we go. But each sector will have to actually look at its own scenarios and maybe take advice on it, but that's where we're going with some of these cases.
Exactly, and it's not just customer perception and for reputational damage, but it's also perception amongst other employees as well. I was talking earlier about health and safety executive actively encouraging employees to report health and safety breaches. So it's about how other colleagues feel and the risk to them by the individuals not wearing the mask as well. That's something that needs to be considered. Looking to the office environment then, so it's not mandatory to wear masks at the moment in offices unless you're customer facing, so for example in a bank. However, we heard yesterday that masks are now being mandated in secondary schools in all areas, not just communal areas as it was previously. We also know from our own experience that we have to wear masks on public transport and when we go into shops. So it kind of feels like masks in the office space is kind of like a gap, a sort of missing when we consider everything else. So our kind of view on this is that your risk assessment that you'll undertake should probably uncover whether mask wearing in your office is something, a suitable measure to implement in order to protect you. So depending on what other measures you're able to take, if you're not able to ensure social distancing, for example, you as a business may decide to mandate that actually, despite the guidance, we are going to make it mandatory in offices. And to add to that, there is a proposal to make it mandatory in offices anyway, and we know that the government is going to be reviewing this as part of its 4-stage reviews that it mentioned yesterday. The point on this is if you are going to make masks mandatory in your workspace, then you have a duty to provide them. That's not to say that employees can't bring in their own masks and wear their own. It's just that if you are mandating it, you need to have enough provisions for everybody, especially if somebody forgets their own, for example. That brought up an interesting question between us in terms of the safety of employees' own masks, whether if you're having a mandatory system, you're going to allow employees to bring their own ones, which may just be a piece of cotton in comparison to those sort of medical grade masks, where you're going to sort of stand on that. And your risk assessment should hopefully bring that out as well and give you a stance on how much or what masks are needed to really ensure that protection. The final point to make on this is having a consistent approach to enforcement. So this is really trying to protect you against potential discrimination claims if you are treating employees differently. So it'll be about if you have an employee who refuses to wear a mask, giving them, for example, a written warning versus maybe moving straight to dismissal with somebody else. You need to ensure that the enforcement is really consistent, and so perhaps having a policy, maybe under your health and safety policy, to really back that up and ensure you've got that consistent way of working with people will really help you to protect you in that scenario. So moving on to the hot topic of the day then, vaccinations.
Yeah, so this has really taken off in terms of becoming quite a controversial area, because it really is a dilemma, because it's all about providing a safe place of work against individuals' rights. And of course, it's a moving feast, because where we are today in terms of that safe place of work could be very different to where we are in 4 months' time, and it could be very different to where we are by Christmas, depending on whether there are variants, and where we are with booster injections. So it is such a moving feast. It's almost difficult to provide answers, but I guess it's giving some guidance, looking at what others are doing, but it's also trying to think about what you as an organisation wants to do and where you are in terms of your own brand, your own values as an organisation, what you want to say to your employees, and what your stance is going to be. And I guess it's what you're going to need. You're going to need to be thinking about it now, and trying to work out what position you're going to take. So we all know, and we'll all have been reading about Pimlico plumbers, and the individual there, the owner of Pimlico Plumbers, who has been saying that he's going to do the no jab, no job for new recruits. But there are other large companies that are already doing the same thing. So Barchester Healthcare has about 200 care homes. They have been saying that they're going to do the same thing, and I'm aware of an engineering company that is also looking at doing the same thing. No jab, no job. This is all for new recruits. Charlie Mullins, who owns Pimlico Plumbers, is also looking at putting together a big fund for existing staff to get them jabbed when they can actually have private jabs when they become available. He's saying that he won't be sacking any employees, current employees, if they don't have a jab, but it will all be about persuading employees to have the jab. So you may well have been reading as well in the press about what are the risks of putting something like this into the contracts of employment, because our vaccine minister has made it quite clear in what he's saying is that it's really up to employers what they do. And I guess that is the case, it is. In terms of contractually, employers can include such a term into their contracts of employment. The issue is whether or not it's going to result in any sort of claim. And whether it's a breach of human rights and the individual's right to autonomy and body integrity, and whether or not you can be forced to have some sort of minor medical procedure, for example, and where that might lead. And actually, none of us know the answer to that yet until we see whether or not there are claims. But just looking at some of the obvious claims, or what we think might be obvious claims, are the discrimination claims. And these are most obviously indirect discrimination claims. There may be some possible direct discrimination claims around possibly pregnancy, but most of them are indirect discrimination claims. You're not actually deciding not to take somebody on because of their age or because of their ethnic background or a disability or their beliefs. You're actually deciding not to take them on because of their vaccine status. And then what that means is that it may be that that group, statistically, you know, it is more people of a particular age are of that vaccine status, or of a particular disability or a particular belief, and that is where the protected characteristic comes in. With age, that is probably going to disappear quite quickly, because we know that the government has said that nearly all adults and probably of working age will have been vaccinated by a particular period, you know, and by the half year. So that age, that claim is going to disappear. But with the others, we've been looking at this and thinking about the actual claim. It's going to be based on statistics, because indirect discrimination claims are based on statistics and being able to prove particular points. And we actually think those claims may be quite difficult to prove. The religion and belief one may be quite difficult, and an anti-vaxxer claim may be quite a difficult challenge to raise. So those claims, although they are potentially there, may be difficult. For individuals who are currently employed, to force them to have vaccine, there may be scope for a constructive dismissal claim. That would be for those individuals who have 2 years service. We're waiting to see what scope there may be for the human rights angle claim, particularly for those in the public sector, where there is a freestanding right for human rights claims, less so in the private sector. So the issue will be the extent to how robust employers are going to be about this. We think that there may be, in any event, a right for an employer to ask an employee or a candidate's vaccine status, even if you can't force them to have a vaccine, so that you can actually look to your measures in terms of your risk assessment, so you can identify what measures you might need to take. So it won't be that you're not going to recruit the individual, but it's so that you can determine what measures you might want to take and what extra measures you might need to take, because you have a workforce that is perhaps, you don't have many people who are vaccinated, for example, or you have a significant proportion that are vaccinated. So if we move on then in terms of vaccinating the workforce, it may come down to the sector and the role that the individual is in. For example, Chris Whitty only yesterday suggested that the NHS and the care sector, that may become a mandatory requirement. So we may see some rules coming out around who needs to be vaccinated and who will have to be vaccinated in order to secure a job. And so it depends how wide that remit goes, but you can understand why those sectors may become mandatory. And you can see perhaps why Charlie Mullins at Pimlico Plumbers is thinking about why his workforce needs to be vaccinated, because he's thinking about them going into people's private homes, into their bathrooms, their kitchens, their toilets, very personal spaces. And you'll see I put on the slide there, looking at perhaps supply chain, customer and client demands. That may be one of his arguments as to, in his sector, why it's important that his workforce is vaccinated. It may be a more difficult argument if you are purely an office-based or in an office-based environment. And it may depend on what other measures you can put in place with regard to masks and social distancing. It may depend on the state of knowledge of transmission, the variants, and the extent to which the vaccines actually prevent transmission, for example. So all of these things are going to come into play, and all of them are a moving feast and a challenge. So the issue for many employers, I think, will be that they won't be forcing vaccination, but it's going to be around communication. And before they decide to perhaps take a more robust approach, it will be getting people over that hurdle before they take a hardened position, if that's what they want to do. It will be encouraging employees to be vaccinated and getting as many people as possible vaccinated. So it will be this persuasion, it will be communication, using team meetings to get information over, using medical experts, targeting disinformation for those groups that are particularly low vaccination levels. And so actually looking at that, perhaps using OH referrals where individuals are afraid of being vaccinated for whatever reason. Maybe it is health reasons that perhaps are misplaced. So it will be all those sorts of issues that will need to be addressed over the coming months and starting to talk to your workforce. But these are the conversations that we think you're going to have to be having now before we start opening up the workplace again.
Exactly, and this is something that we, whilst it may be a short-term issue at this moment in time, thinking that everybody is going to be at least offered their first vaccine at the end of July, actually this is probably not going to go away. It's going to be around for a long time, because we're already hearing about AstraZeneca making their booster jabs to combat variants. We think it's going to operate, and they've said that it's going to operate like flu, in that people will be inoculated each year with new vaccines to combat the variants. So this is something that's probably going to be around for a while and keep raising its head as an issue.
Yeah. So that is the end of our main presentation. Thank you for listening. We have got sort of 5 minutes to answer some questions, and I can see that our moderator is sending through some questions already. So I'm going to pick out a few that we can answer. So I can already see there's one on furlough. So if I ask Georgia if you want to pick up the one on furlough.
Okay, yeah, so there's one here. It says, is it an abuse of the furlough scheme to furlough employees who refuse to wear a mask at work? Okay, so this is a really interesting one because I think to start with, it's going to go to why. What's the reason why they can't wear that mask at work? For example, if it's a disability, we might decide, yeah, okay, it's a reasonable adjustment to furlough them, and we know that the purpose of the scheme, or one of the terms of the scheme, is that employees can be furloughed for health reasons and reasons related to COVID. So in those situations, we think probably, yes, furlough is okay. But for those employees that are simply refusing because they don't like wearing a mask or it's an inconvenience, we think probably not. It doesn't really feel like that's in the spirit of the scheme to just allow somebody to be placed on furlough because they don't want to wear a mask. So it's going to be really important to sort of think about the reason why.
So this is where we've been using it in the retail sector. So where individuals are saying that they're exempt from wearing it, and it causes anxiety, etc. So it may be pushing it slightly on the boundaries, but it's avoiding dismissing the individual and using the furlough scheme for that purpose, and taking the wording of the scheme that talks around the individual's health being affected by COVID, and so deciding that on that basis, that's how we will use the scheme. Rather than actually taking it to the point where we have to dismiss the individual because they cannot work from home.
Yeah.
So that's answering that one. I can see, sorry, there's another question on masks, which I can see there's a lot of questions on masks. It's a controversial topic, but it just says, can I dismiss someone who refuses to wear a mask at work? So obviously it depends, this will depend on all the circumstances and your policies and procedures, and also whether it's part of the law, because there is actually laws on mask wearing in certain sectors. But actually, it's interesting, it's worth knowing that there has been the first tribunal case on mask wearing. So Kent Foods went to tribunal, and the case was only heard, and the decision came out last week. Kent Foods actually, there was no requirement to wear a mask. This was in a lorry where in the cabin, so it doesn't matter whether it's a lorry or anywhere, it's like an office-based mask wearing. There was no requirement to wear a mask, but the company had a clear policy on mask wearing and said that they had to wear the mask even in their personal space in the cabin of the lorry, and even when they went to third-party sites, because their third parties also demanded that they wore masks on site. So this is a third party requirement. And that was partly because when they leaned out of the cabs, they wanted them to be wearing the mask because they would be talking to individuals and in close proximity, leaning over them, and so could be actually causing effectively spray and passing on the COVID. And in that case, the tribunal said it was absolutely very clear what the rules were. They'd made it clear, they'd communicated the policy. Third party had made it clear what the rules were. He'd been asked at least twice to put on the mask, and he'd refused. And in that case, the dismissal was fair, and it fell within the band of reasonable responses. So actually, you can see that as long as you have got your processes in place and your rules in place and your policies in place, in coming back to the office-based environment, it will be possible to dismiss someone who refuses to wear a mask, subject to looking at issues around possible disabilities.
Yeah.
But that I think in many cases there won't be many disabilities related to mask wearing.
Yeah, and we think it's going to be sector specific as well, because in this case that's just come through, it was really important that actually the third party required the mask wearing as well. So it meant that when the individual refused to wear the mask, they were banned from that third party site, meaning that they couldn't actually do their work. And there may be a lot of businesses listening today who have supply chain requirements, as Helen mentioned earlier, where you have your sort of end client who's requiring mask wearing or vaccines or whatever it may be. That means that your employees have to have those measures in place to be able to go and work at those specific sites.
Okay, and then I think there's perhaps a final question. We've got one on...
Yeah, on vaccines. Yeah, so it says, what if someone wants to continue to work from home because they don't want the vaccine? Okay, so again, I think the starting point is going to be coming back to the reason why that person is not having the vaccine. So that question specifically said they don't want the vaccine. So we think in that scenario, if it's a want rather than because they can't, so disabilities is obviously different. But we know there's only a small group of people probably who can't have the vaccine, so people with allergies or perhaps pregnant women. So if your individual is saying that they don't want to work from home because they haven't had the vaccine, this comes back to, and I think our stance on this would be, if government guidance is that we can return to work and you've made your workplace COVID secure and you've shared your risk assessment with employees, you should be able to get them to come back in. If your place of work is the office, you know, that's where they should be working. If you can, obviously, or you allow your employees to continue to work from home, then obviously that's a choice. But it kind of goes back to what we were talking about earlier with the information that we're getting through now on the importance of teamwork and productivity. So it'd be about whether you want to allow an individual to continue to work from home when the rest of your workforce is back in, simply because they don't want to be vaccinated. So it kind of become a bit of an issue. We think that overall, you probably will be able to enforce them to come back in, and not wanting the vaccine alone would be enough.
Yeah. So I think we've finished on time. We hope you found the seminar useful. I hope we haven't raised, although we probably have raised more questions than we might have answered, but these are things that as an employer, you're going to have to think about over the next few months. And we will keep putting stuff out as we hear more from the government, as we have these 4 reviews on almost a monthly basis, as they start to look at the data as it comes through. And I suspect that may start changing things as we start to look at things, and we will keep putting stuff out as we hear things. And I suspect the views on vaccines will continue to progress and possibly change. And so we will keep people informed as we actually you know, gather our views on that as well.
Yeah, exactly. So thank you very much for coming. As we mentioned, we're going to be sending you 2 checklists after this webinar. So the first one is on changing terms and conditions, and the second one is on workplace testing. You'll also receive a copy of the slides as well as a recording of the presentation. So please do share this around your team if you found it useful and interesting, and thanks again for coming.
Thank you.